equity came from the Latin word equus and derived from the French word equitas, means fairness. In the early Roman legal system, there were 5 legal actions called legis actions used to enforce the civil rights. Jus civili were strictly followed but confined within the legis actions. The inclusion of equity in the Roman legal system done through the appointment of the praetors, that is the chief judicial magistrate in Rome in 366 BC. They were given the exclusive powers to change and modify the law. Office of the praetors issued edict wherein stated the rules and procedure to be followed throughout the year. The edict were called edictum perpetuum. The edictum perpetuum runs in the consecutive years were called edictum relatinum. Praetors administered both civil law and equity, where the jus civili could not provide the adequate justice within the legis actions. The praetors introduced a new set of law based on the moral convictions called edictum novum. The edictum novum, that is the equity, runs along with the civil law, that is jus civili, in the Roman legal system. When the common law of England was not able to fulfill the justice in all cases, or not all cases falling within the ambit of the common law, the dissatisfaction arose among the people and number of petitions were submitted before the king. At that time, that is the 13th century, the Court of Chancery came in England and introduced a new concept of law, that is the law of equity. In the word of Aristotle, equity isn't a virtue all its own, but that people with the virtue of justice ought to have the virtue of equity. To him, justice to be delivered with equity, not with the rigidity of justice alone. The chancellors in England developed the new remedies to meet the new cases which does not fall within the clothes of the common law. To provide the more comprehensive justice than the remedy of damages, introduced injunctions, specific performance, declaratory relief, estoppel, subrogation and others. In the Earl of Oxford case 1615, Sir Francis Bacon decided that when there is a conflict between the common law and the law of equity, the law of equity will prevail. The principles of equity stands are based on the maxims developed by the courts of England. Some of them are as follows. 1. He who comes to equity must come with clean hands. 2. Delay defeats equity. 3. Equity looks into the intent rather than the form. 4. Equality is equity. 5. Equity follows the law. 6. Equity regards as done what ought to be done. 7. Equity will not suffer wrong to be without remedy. 8. Equity acts in personam. 9. Equity imputes an intention to fulfill an obligation. 10. He who seeks equity must do equity. The concept of equity in India is not new. The concept was found during the early development of the Hindu law. The Smritikar always accepted the reasoned thought when there is a conflict. In the Islamic laws, there is the partial presence of equity. In the post-independence period, the law of equity was inserted in the statutory law. The Specific Relief Act of 1877 was repealed, and in 1963 Act, the equitable concept was codified as statutory law. Numbers of doctrines of the equity is found in the Transfer of Property Act, Contract Act, Trust Act. Thus, the law of equity has gained its importance in the Indian legal system through the enactment of the various statutory laws.